Members of the jury, the plaintiff's cause of action is stated in the complaint which was read to you at the beginning of the trial. To this complaint, the defendant has filed an answer denying the allegation of negligence charged against him in the complaint and denying every proposition of fact that is required to make out a case of liability against him. Before there can be a recovery in this case in favor of this plaintiff or any plaintiff in any case, the law imposes upon him or her the duty to prove by a preponderance of all or any evidence that the defendant was guilty of any negligence of one or more of the acts of negligence charged against him in the complaint. The burden is also upon the plaintiff to prove that said acts of negligence were the proximate cause of the collision in question and that as a result she may have suffered damages as may have been shown in the proof. If you find from the evidence and believe from a preponderance of all of the evidence that the collision did happen as charged in the complaint of the plaintiff, then it would be your duty to find in favor of the plaintiff. But if the plaintiff has failed to prove by a preponderance of all of the evidence that the defendant was guilty of any negligence in any one or more of the particulars charged in the complaint, or if after consideration of all of the proof you find them in equal balance as to the way and manner in which the collision did occur, then in that event, if you so find, your verdict should be in favor of the defendant. It may be stated as a general rule of law that every driver of a motor vehicle owes the duty not to drive negligently. Therefore, before the plaintiff can recover in this case, she must prove by a preponderance of all the proof that the defendant she has sued is guilty of an act of negligence as charged in the complaint within the eyes of the law. In everyday language, the plaintiff must prove that the plaintiff must prove that the defendant was at fault or at blame for the collision, and that such fault or blame was the direct fault and proximate cause of the injury of which the plaintiff complains. Negligence is defined as the failure to use and exercise ordinary care. That is the care that a reasonable, cautious person would use or would have used under the same or similar circumstances. Of course, you would understand by this definition that negligence may consist of doing some act that an ordinarily careful and prudent person would not have done under the circumstances. By these definitions, you would also understand that ordinary care is a comparative term, and what is required by it depends upon the facts of each particular case. Ordinary care means such care as is commonly exercised by the majority of the persons of ordinarily prudent habits in the community when placed in similar circumstances. If the concurrent negligence of two persons combined together results in an injury to a third person, he or she may have recovered damages of either or both, and neither can interpose the defense that the prior or concurrent negligence of the other contributed to the injury. The rule is well settled in this state that if an injury occurs from two cases, both due to the negligence of different persons, but together constituting an efficient cause, all persons whose acts contributed to the injury are liable therefore, and the negligence of one does not excuse the negligence of the other. In a suit based upon actionable negligence, the law imposes upon the plaintiff to prove by a preponderance of the testimony, first, a duty which the defendant owed to him, second, a negligent breach of that duty, and third, an injury or damage either in his person or property as the direct and proximate cause of such breach. By proximate cause, it may be said to be that act or omission that causes or fails to prevent the injury. It is an act or failure to act occurring with another which had in it not happened, the injury would not have been inflicted. It is a cause of which the injury is a natural and probable consequence. It is the duty of an operator of a motor vehicle to keep a reasonably careful lookout ahead to see the objects and things that ought to be seen, and by the exercise of reasonable care should have been seen, to be reasonably vigilant and to anticipate the presence of others. to give timely warning of his approach if necessary, to drive at a speed not excessive under the circumstances and not in excess of the legal speed limit established for the place or zone of his travel, to keep his vehicle under reasonable control so as to stop it within a reasonable degree of quickness so as to avoid an accident. In other words, to do every prudent act or thing necessary or reasonably calculated so as to avoid injury. The plaintiff has alleged that this defendant's automobile was not under control. A vehicle is under control within the meaning of the law when it is moving at such a rate of speed, not in excess of legal speed limits, and the mechanism and power are under such control that it can be brought to stop with a reasonable degree of quickness under all the circumstances. Therefore, if a driver, by the exercise of due care, anticipates danger from another vehicle, it is his duty to operate his car so that it can meet the obligation of law requiring a vehicle to be under control. The plaintiff has defined and set out in her complaint the ground upon which she seeks a recovery, and you cannot go beyond or outside of these grounds as they have been stated.